Morning, Your Honors. May it please the Court. My name is Michael Smith. I'm the attorney for the appellant, Deutsche Bank National Trust Company, and I would like to reserve 5 minutes for rebuttal.
Are you with DPW Legal?
I'm with Baker Donaldson. DPW is on the appellee side.
Okay. And your name was?
Michael Smith.
Okay, I see. Thank you.
Thank you, Your Honor. Your Honors, this is the appeal of an order of dismissal at a motion for summary judgment in a foreclosure proceedings, a mortgage foreclosure proceedings. And it is our contention that the trial court erred in granting the motion for summary judgment in 3 particulars. One, that the borrower, Barry Patterson, waived the defense of failure to comply with the conditions of proceedings. 2, that the court improperly resolved material issues of fact in this order granting summary judgment. And 3, that the breach letter, which the court found was not in compliance, actually did comply with the terms of the mortgage. I'd like to briefly go over the procedural history as it is relevant to the case. The complaint was filed in March of 2009. Later that same month, the borrower filed a very brief answer. In that answer, the borrower, it had a case caption at the top. It was signed by the borrower, and the borrower stated, "I request that my response to said complaint be observed. I wish to have my side heard in this case." Deutsche Bank then filed an amended complaint later in 2011 to add a homeowners association that had been omitted. The borrower did not file an amended answer, and in fact never filed an amended answer. 3 years after the filing of the complaint in 2012, the borrower filed a motion for summary judgment, and for the very first time raised the argument that the bank had not complied with all the conditions precedent in the mortgage, specifically that the paragraph 22 breach letter had not been complied with. He alleged that it had not been sent, and even if it had been sent, that the copy that the bank relied on did not comply with the terms of the mortgage. So there are 3 questions. First, did the defendant actually file an answer? And by filing an answer, did that defendant waive that defense? I think unequivocally the answer is yes. The defendant did file an answer. Again, that answer was directed, it was filed with the court. It stated that the defendant wanted to controvert the allegations that were in the complaint, and that he was going to fight the allegations. There were no other defenses raised. It's axiomatic that if you fail to raise defenses specifically and with particularity, that those defenses are then waived. Mr. Patterson did not raise any defenses, and therefore he has waived those defenses. And that is a very simple issue. The second one, the trial court, in its order of dismissal, decided issues of material fact. Now, there was some question as to whether or not this was, in fact, a motion to dismiss or a motion for summary judgment. It was styled both a motion for summary judgment and or motion to dismiss. But we'll treat it for purposes of this as a motion for summary judgment. The defendant filed an affidavit, and in that affidavit, the defendant said that he did not receive the breach letter. Now, the court, in its order of dismissal, does not address that at all. The court apparently decided that Mr. Patterson did in fact receive the breach letter, because the basis for the order of dismissal was very simple. It stated that the letter in question did not inform the defendants of the right to reinstate after acceleration, as it indicates they may have this right, number 1. And then number 2, the letter does not specify that failure to cure the default may result in foreclosure by judicial proceedings, or that defendants have the right to assert defenses in that proceeding, but falsely advises defendants they may have the right to bring a court action. Now, Patterson said that he did not even receive the letter. And the court has decided that he, in fact, did receive the letter.
Isn't it possible that the reasoning was whether he received it or not? I mean, the letter is insufficient. Now, whether it's insufficient is another question, but I mean, the reasoning could be, doesn't matter whether he received it or not, the letter was insufficient.
Yes, it absolutely could be that. I'd like to argue that Mr. Patterson inserted a question of material fact when he said that he did not receive that, and the court decided that by skipping over that and skipping straight to the merits of the letter, really in fact decided that for him. When Mr. Patterson has no knowledge as to whether or not the letter was actually sent. The mortgage only requires the letter to be sent. It does not require receipt. Mr. Patterson cannot assert with any basis at all whether or not the letter was sent. If he were to testify in trial and state the letter was not sent, there would be an objection for lack of foundation. He has no idea whether or not the letter was sent, and he cannot inject that into an argument on a motion for summary judgment. That gets to the third issue, which is the one that you raised, the sufficiency of the letter. The mortgage requires 6 very specific things to be provided to the borrower in a mortgage foreclosure action. One, it has to state that the borrower is in default. 2, it has to state the action required to cure the default. 3, it has to provide a date within 30 days from the date the notice is given by which the default must be cured. 4, that failure to cure the default may result in acceleration of the sum secured by the security instrument. 5th, the notice shall inform the borrower of the right to reinstate after acceleration. And 6th, the borrower has the right to assert in the foreclosure proceeding the non-existence of a default or any other defense of borrower to acceleration and foreclosure. Now, Florida law is clear that when it comes to compliance with the conditions preceding the law of substantial compliance. Now, I didn't have to turn around to know that opposing counsel is stiffening up to that, because he and I both know that there is not an appellate case in Florida in the mortgage foreclosure area of law that specifically states that substantial compliance with conditions precedent is the law. It's in other areas of contract law, but nothing specific to the mortgage foreclosure realm. However, there are 2 very recent cases, one right here out of the 2nd and one in the 5th, which, although they don't use the word substantial compliance, they very clearly show that substantial compliance is the norm. I first refer to the Busquets case. The Busquets case dealt with 2 issues, one of which was in this raised in this argument or in this action as well, that the borrower may have the right to reinstate, and the court found that the right to reinstate was always conditioned, so the use of the word may did not destroy the notice. Second, there was an issue as to whether or not the borrower would face foreclosure proceedings versus judicial proceedings. Paragraph 22 requires notice of judicial proceedings. The letter in Busquets said that it was going to be foreclosure proceedings. Now, the court in Busquets found that the language of the notice adequately describes the proceedings that Busquets might face. It didn't say it precisely describes, it didn't say it strictly describes, not exactly describes, but it adequately described. Given the idea that even though the language did not mirror exactly the words that are in the mortgage, the idea is to give them substantially the idea of what they're going to be facing. Now, Samaru was different. Samaru, the court found that the bank completely did not give notice of the borrower's right to acceleration. So there not only was there not substantial compliance, there was no compliance. So the court found that there are these 6 things that you have to give. 5 out of the 6 is not good enough. And I'll submit that that is the right answer. But if you were to substantially comply with that for the Busquets decision, I think that would be a different result. So these 2 cases read together show that it is not strict compliance that matters. It is substantial compliance. And then Samaru shows the limits of that substantial compliance. 5 out of the 6 is just not good enough. Looking at the breach letter in question, I would submit that it does substantially comply with the terms of the mortgage. First, a default. The letter advises the borrower that this is formal notice that you're in default under the terms of the documents because you have not made the required payments when they came due. Second, it tells the borrower that he is required to pay the amount that is in default within 30 days of the date of this letter. It later states, because of interest, late charges, and other charges that may vary from day to day, the amount due on the day you pay may be greater, and therefore advises him to contact the servicer, which was Saxon Mortgage Servicing, to inquire as to the exact amount. Now, the mortgage does not say you have to provide the borrower with a sum certain. That is the only way that you can comply. It says you have to give notice of how they can cure that default. That notice in this particular case was for the bank to say, look, you owe this amount right here. Now, because of the way the mortgage works, you are accruing interest daily. If you take your sweet time in paying us, it is going to continue to accrue. So this is what you do.
Doesn't your argument kind of is in violation of your own paragraph 22 regarding the acceleration, what the lender shall give? If you're requiring the borrower to be placed on notice of his default, and then there's this time will tick, he has a certain period of time to make good on the whole amount, for him to call the bank and to find out what that amount is, doesn't that kind of fly in the face of the actual requirement of paragraph 22?
I don't think it does, Your Honor, and because that requirement is, in light of today's technology, is so easily done. It is done the day you call, and then you make the payment that day.
Okay, but that's assuming when you call, you get a live body. In this day and age, you call, you get a recorder, and if you need to buy, I guess the bottom line is,
hold on, we'll get to you.
the concern that I have is that you're making demand, you're in default, you're making a demand, your client has all the information, including what the total amount that's due and owing, that's requiring the borrower to pay in full. And you're saying, oh, call us, we'll give you the amount. Isn't that deficient?
I don't think it is, and I don't think we can make the assumption that they are not going to get a live person. We have to go based upon what is in the record. And the record says, we'll give you notice, or here is what you owe, and the exact amount, again, dependent, because they don't know when they're going to pay. And you would agree that the mortgage continues to accrue interest daily. So they would not be able to cure that default if they were to wait the 30 days and then pay that amount that was due previously.
That could have been easy. That could easily be remedied. You owe $1,000 as of whatever date, and if you fail to pay by, then every day you need to add, and you have the exact amount, so that individual's placed on notice, here's the amount that's due and owing, and that will comply, because it says shall specify. It doesn't say may specify. Your acceleration provision shall specify, and it tells them in specific, you need to put them on notice what it is they have to pay. Wouldn't you agree with that?
I agree that your solution is a better solution. I do not think that this particular way the bank chose to do it is deficient, because it says it has to tell them the action required to cure the default. That is the action. The action is to pay this amount, and then whatever else comes due. And how do you know it comes due? Is we'll tell you, because we don't know when you're going to make that payment. It is not required. I agree, your solution is much better, but I do not think that the solution is deficient, because it is not perhaps the best solution that they could have come up with. The third requirement, I believe it's clear that the letter requires payment to be made not less than 30 days from the date. I think it's also clear, no question, that the letter specifically says that the borrower, or that failure to cure can result in acceleration. I want to get to the, and that they have the right to reinstate as well. I don't think those are in dispute. However, I want to get to the very last one, which is what the trial court had a problem with. The trial court specifically found that the language regarding the borrower's right to a certain foreclosure proceeding was deficient. Specifically, the language in the notice says that you have the right to bring a court action to assert the non-existence of a default or any other defense to acceleration that you may have. Now, I will admit this does not track the language of the mortgage. telling of the borrower that instead of asserting a defense in a foreclosure proceeding, that said they have the right to bring their own court action, does not track the language of the mortgage. However, the purpose of this acceleration notice, the purpose of the breach letter, is to give the borrowers notice as to what is going to happen. And read in the totality of the notice, the borrowers are being told, look, you're in default. You need to pay this. If you don't, we're going to foreclose. There's going to be a judicial action. You have the right to fight this. You have the right to assert any defenses that you may have, thank you, Your Honor, in this foreclosure action. Given the totality of the circumstances, is our position that the borrower is put on notice that he has the right to fight this foreclosure action. And this is not the first time the borrower has seen this language. The defense bar would make us think that the breach letter is the only time the borrowers are made aware of the remedies. It is not. If we are to assume that the borrower reads this breach letter, then we also have to assume that the borrower originally read the mortgage. The mortgage has this clause in there. The mortgage tells them what's going to happen in the event of a default. Now, I'm not suggesting at all that the mortgage takes the place of the breach letter, because it does not. But if you take the breach letter and read it in conjunction with the mortgage that they already read and signed and agreed to, I think it is clear that the borrower has an understanding of what is going to happen in case of default and has an understanding of the rights thereunder. Thank you. Sorry.
May it please the Court. I'm Mark Stopa, counsel for the Appellee, Barry Patterson. Your Honors, I fully want to show you why I believe that the content of this letter was deficient and that the lower court ruled correctly. But there are two issues that I think we need to address that my opponent really hasn't addressed at all as to why we don't even get there. The first issue is there is no letter. For purposes of this proceeding, there is no letter because there was no authenticated letter before the lower court. The Hummel case that I cited in my brief that you joined in, Judge Castanueva, decided by this court in 2002 is directly on point. In that case, this court ruled that it was a departure from the essential requirements of law for the circuit court to have considered unauthenticated letters stuck in a file at a summary judgment hearing. That's precisely what we have here. My client filed an affidavit showing that the paragraph 22 notice was not given. My opponent did not file any affidavits or summary judgment evidence on this issue.
How would he know that?
I'm sorry?
How would he know that?
How would he know what? I'm sorry?
How would he know that the letter was not sent?
Well, a couple issues there, Judge. First, our affidavit doesn't say that the letter was not sent. It says the letter was not received and that they did not give the notice. Now, giving the notice is exactly what paragraph 22 requires, that the notice be given. Now, my opponent did not, he tried to argue before Your Honors today that the issue is whether the notice was sent, but they didn't even argue that in the briefs. That's not even argued in the briefs at all. The closest that they came was in the very last paragraph of their reply brief when they said appellee's statements regarding whether appellant even sent the notice should be disregarded because he wouldn't know. But they didn't even argue that issue in their briefs. And they did not designate any summary judgment evidence under the summary judgment rule at all. For instance, if they wanted to take the position that the standard was whether the notice had been sent pursuant to a different paragraph of the mortgage, they could have designated that as summary judgment evidence. They didn't do it. So all that the lower court had before it was an affidavit that my client was not given notice, which is exactly what paragraph 22 contemplates.
Well, that's really not the basis upon which the trial court decided the case, was it?
Well, Judge, and that gets to the second point that my opponent has glossed over, which is it's their obligation to show that the lower court erred, and they don't have any transcript of the proceeding. They did not recreate the record at all. I cited the Rose versus Clemens case, a first DCA decision from 2007 that said you can't even consider whether the lower court erred because they didn't show what happened. They're making supposition, and my opponent did it in his argument about.
They filed a memorandum in opposition to your motion for summary judgment that raised a lot of issues, so I think we have some idea as to what their position was.
Well, but Judge, and sure, but even from their memorandums, and I made this argument very clear in the briefs, their memorandums don't say anything about the alleged failure to plead conditions precedent. They don't say anything about waiving this conditions precedent as a defense by filing a pro se answer. They don't say anything about the issue of prejudice. They don't even argue that there are facts in dispute. Like, if you look at their motion for rehearing, it makes clear they frame this as a legal issue, not that there were any facts in dispute at all, nothing about the letter, whether the letter was sent or not, or anything like that at all. And I think it's telling that I made the first issue in our answer brief, preservation or lack thereof, and they don't even comment on that in their reply brief, and they didn't even argue it here at the oral argument here. They're just totally ignoring the concept of preservation when it was their burden to present the court with evidence, or with something showing what happened, a transcript of the proceedings, recreating the record. They want to come before your honors and say the lower court erred when they're not even showing what the lower court, showing this court what happened.
We want to talk about a muddle. There was no answer filed here.
Well, Judge,
And
I'm sorry.
not only that, we've got a motion to dismiss that attacks the sufficiency of the complaint combined with a motion for summary judgment, which is something very different, and it's really very hard to know on this record the basis for the trial court's ruling. Is he ruling on a motion to dismiss? Is he ruling on a motion for summary judgment? I don't know.
Well, Judge, I think it's clear, a few responses to that. First, it's their obligation to show that the lower court erred. If they don't show what happened, then they fail. Second, their own motion for rehearing makes clear this was an order granting summary judgment. That's what they sought rehearing on. That's very clear what transpired there. And the law is very clear that when you have a summary judgment on conditions precedent, that the remedy is to dismiss without prejudice. That's the Whistler's Park case that I cited out of the 5th DCA and the Wright case out of the 4th DCA. But Judge, the issue of, there's nothing that prohibits the filing of a motion to dismiss and a motion for summary judgment in the same document. I certainly agree they're different legal standards, but I think it's clear on this record that the summary judgment is what was adjudicated. The remedy was to dismiss the case without prejudice, and the procedural arguments that my opponent makes about, well, the pro se answer and pleading conditions precedent are all waived and not preserved because they didn't argue them below in any way at all, and even if they had, respectfully, they're wrong, because
Let's talk about what the trial court did rule on, okay? As I see it, the trial court said two things. He said the letter in question does not inform defendants of the right to reinstate after acceleration, as it indicates they may have this right. And your opponent argues that our recent decision in the Busquets case addresses that. Do you agree with that?
I think Busquets is close on that, but where Busquets is different on that defect in the letter is that the letter in that case, and the opinion makes clear that it said you may have the right to reinstate, refer to your loan documents for additional information. It's referring you back to the loan documents so that you see what you have to do in order to actually reinstate. This letter didn't say that at all. It doesn't tell you to refer back to the loan documents in order to ascertain what you do. Instead, it just says you may have the right to reinstate the loan after acceleration. So,
yeah, but Busquets says that there's so many factors that would impinge on the right to reinstate that use of the word may is not misleading or improper in this context.
And Judge, if you think that that aspect of the letter is sufficient, then, I'm not going to argue too much with you because there's a ton of other defects in the letter that I think are very clear and frankly are worse than that one. For instance, in that same paragraph of the letter, you also have the right to bring a court action. That is not what paragraph 22 requires. Paragraph 22 requires that this notice shall inform the defendant of the right to assert in the foreclosure proceeding the non-existence of a default.
Well, let me ask you about that then. The circuit court cases that have been decided seem to take the position that substantial compliance with regard to that requirement is sufficient and that this language is sufficient.
Well,
you
Judge,
want to address that?
I'd love to. I have a blue box that I'm known for carrying with me. I have hundreds of circuit court orders on this issue. Frankly, I stopped citing them because now we have DCA decisions that are on point on how we adjudicate these issues. You have Samaru and Haberl out of the 5th DCA.
Those are cases where no notice was sent. They don't address the judicial foreclosure versus non-judicial foreclosure question?
Well, there is no DCA decision on the right to bring a court action language versus foreclosure
And that's what the judge ruled on here. That's
Well,
what we're talking about.
That's one of the defects with this letter, if you even get to the letter, correct. That's one of the defects in the letter. But Judge, I can, if you want a supplemental memo or something, I can string cite circuit court decisions as well on this issue. It's not the same thing to tell a consumer that they can go file a lawsuit in order to.
All right. The issue is whether we're going to have a magic word approach to this or look at whether or not substantial compliance satisfies the requirement. Wouldn't you agree?
I don't think so, Judge. I don't think magic word is the concept here at all. I think substantial compliance has been rejected. I think you rejected it in the Judy decision, which you joined in, where that decision could have employed a substantial compliance analysis. It didn't. The cases all employ a compliance analysis. No decision has ever employed a substantial compliance analysis. The two decisions from this court, Judy and Busquets, and the two from the 5th DCA, all make clear that it's a compliance standard. Essentially, as a matter of law, the judge looks at the letter, compares it to paragraph 22, sitting them side by side.
Let me ask you this. How was your client prejudiced by the use of the language about bringing a lawsuit versus asserting defenses? Where's the prejudice to your client?
Well, Judge, I submit a couple of responses to that. First, the issue of prejudice is not in this court record. And the reason for that is because, one, they didn't argue it and preserve it, as would have been their burden, and two, that is not a factor under the case law at all. For instance, in Judy, the decision that you joined, that letter did not specify the default. It would be easy to...
If we're talking about, asserting defenses in a judicial foreclosure, you certainly did that on their behalf. So, and there's no evidence that they thought they had to file a separate judicial proceeding to assert their defenses, so how are they prejudiced?
Judge, this paragraph 22 was drafted by the lender. It's the only paragraph in...
The first thing you do is you answer my question. If you want to explain and go on, that's fine, but the first thing you do, sir, is you answer the question that's asked.
Your Honor, I'm trying to. I apologize if I didn't. I don't think that the record reflects the existence of prejudice. I don't think that fact exists on the record. I'm trying to be straightforward in asserting that. My argument is that I don't believe that is a preserved issue before you, and even if it were, I don't think that that's the law. All of the DCA decisions make clear prejudice is not a factor in the analysis. None of them employ a prejudice analysis. 3 different DCA decisions, including one from this court, have found letters, paragraph 22 letters, to be fatally defective without employing a prejudice analysis. It would have been easy in any of those decisions, including your Judy case, for the court to rule, well, this letter doesn't say what it's supposed to, but the homeowner wasn't prejudiced, so it's no harm, no foul, we're going to affirm the summary judgment. None of the decisions do that. The established precedent in Florida is that prejudice is not part of the analysis. The entire concept of prejudice emanates from insurance cases, and in the insurance context, it's totally different. What's different there? There it's the consumer who is having to comply with the condition precedent in a contract that the insurance company, the behemoth financial institution, drafted. Here, it's the bank that should have to comply with its own condition precedent in a contract that it drafted. We don't look to the concept of substantial compliance or prejudice when we're talking about a bolded paragraph in a document that the bank drafted that it itself has to comply with. That's why there's no case law on that issue, and why my opponent can't cite any on that issue. The 5th DCA decisions in Samaru and Haberl make clear, and Judy, they all make clear it's compliance. Samaru specifically rejects the concept of substantial compliance. They call it, quote, an argument we cannot credit. An argument we cannot credit. And they say the letter does not comply. Haberl, the ruling was that the letter did not comply. Judy, the letter was that the letter did not comply. I string-cited cases that all talk about compliance or satisfying on page 23 of the answer brief. Judge, that's what all the cases provide, and that's why I didn't provide circuit court decisions like I did the last time this issue came up before this court. We have enough DCA decisions in order to see that that's what the law is on this point. I think that the other defects in the letter, and Your Honor, your questions were particularly appropriate to my opponent. The point of paragraph 22 is to provide an opportunity in order to avoid a foreclosure. We should be able to look at the letter and know what you're supposed to do in order to avoid getting sued.
Let me ask you this question, Mr. Stofa. Let's assume that you're correct and that the letter is defective and there's no acceleration. What's the result then?
Well, I think I know what you're hinting at. The result is that the case has to be dismissed without prejudice because for a few reasons. One, that's the correct legal result. Two, that's the only issue that was argued. My opponent did not make any argument whatsoever, either in the briefs or at this oral argument, that the remedy of dismissal, assuming that the letter did not say what it was supposed to say, is wrong. So dismissal, if you agree with my position in any of these issues, dismissal is the appropriate remedy. They haven't challenged that. To the extent that your question hints at a recent decision called Holt out of the 4th DCA that is not in these briefs at all, I submit that that decision was not only given without case law, but is wrongly decided because if you look at the second to the last sentence of paragraph 22, it provides very clearly on its face that you cannot foreclose without compliance with paragraph 22. The only paragraph the only sentence in the entire mortgage that authorizes foreclosure is that second to last sentence of paragraph 22 that authorizes it only if the default is not cured on or before the date specified in the notice. That's when lender may foreclose. So the right to foreclosure in the party's own contract is triggered by the giving of the notice. So to the extent your question is contemplating some sort of remedy of, well, the letter is defective so they can't accelerate, but they could still foreclose on installment payments, my answer to that is no, because not only did they not brief that issue and not argue that issue, so you can't award them relief that they didn't argue, but paragraph 22 is clear on its face that the notice has to be given prior to acceleration, or prior to foreclosure as well as acceleration. And all of the panel decisions from this court have made clear that paragraph 22 is a condition precedent not just to acceleration, but to foreclosure as well. The cases that have been decided on this issue by this court all talk about it's a condition precedent to foreclosure. So there's no way around that issue, certainly not in this case, even if you disagree with that, particularly since you have to follow the panel decisions, I guess, unless you're going in bank, but even then they didn't brief the issue. So I hope that answers your question on that. I think that's what you were hinting at was the Holt decision, Judge. Judge, we don't even, I think it's important, and I want to make clear, we don't even get to the letter because they did not have any summary judgment evidence of the letter. Attaching a letter to a memo does not make it summary judgment evidence that can be considered as a matter of law. So one of the things I argued in the briefs was the concept of invited error. They asked the court to consider a letter that it couldn't even consider at the summary judgment hearing because it was not authenticated or attached to an affidavit. And I listened to Your Honor at the first oral argument today talking about, well, the letters that were attached to that complaint were not authenticated. It's the same thing here. They didn't authenticate it, so it can't be considered. So they don't get to ask the court to consider it and then come to the appellate court and say the court erred by considering this letter, which it shouldn't even have been considered in the first place. And on the pleading issues, I want to be clear about and before I move on there, they had more than a year to file an opposing affidavit. We raised this summary judgment argument in April of 2012. We filed the affidavit in support in July of 2012. The hearing was not until July of 2013. They had a year to file an opposing affidavit, and this was a 2009 foreclosure case. For 4 years, they could have filed an affidavit to say, here's the paragraph 22 letter, here it is. I mean, we're challenging this as best you possibly can in a case like this by saying there's no letter. They didn't give us notice, as paragraph 22 requires. They have a year to do it, and they file nothing. So I don't submit that their complaints on any issues like that are well taken. I also submit their pleading arguments are not only not preserved, but they're just wrong. Because the pro se letter that my opponent complains about, that he read to you, that was 2 sentences long, my client's initial answer to the original complaint, do you know how many cases they cite to support the position that that's an answer? 0. 0 cases. I cited 3 cases that the holdings of those are that letters like that do not constitute an answer. They're just a letter. And even in the reply, the only cases that they cite to try to contravene that are cases which discuss the propriety of a default, where a defendant chooses not to defend after an amended complaint is filed. And the cases say, well, you can't be defaulted where you answered the original complaint, because then that carries over to the amended complaint if the amended complaint was substantially similar. So they have no cases on point that show that's not an answer. But even if it were, and even if you thought, you know what, Mr. Stope, I don't agree with you, that letter was an answer, they filed an amended complaint. Once they filed the amended complaint, our right to respond, it gets triggered anew, and we responded with the motion to dismiss and for summary judgment. The Florida Supreme Court case of Coral Ridge, decided in 1987, I quoted in my brief, makes clear a defendant can move for summary judgment at any time, even based on something that would traditionally be characterized as an affirmative defense, even without having filed an answer yet. Why? Because the summary judgment rule allows the defendant to move for summary judgment at any time. That's what we did. We didn't have to file an answer, and we responded anew by filing the amended complaint. And they didn't preserve any of that stuff because there's nothing even in the memos that they filed. You asked a question, Your Honor, about, well, they showed their position by the memos. Sure, but nothing in those memos talked about or complained about, well, they didn't plead this conditions precedent. Nothing did that at all. Clearly, the issue was litigated by consent. They have nothing at all showing the contrary. They argue. So I argue, based on there being no authenticated letter, no summary judgment evidence designated in opposition, and no opposing affidavit, there are no factual disputes. What does their brief say in response to that? Their reply brief on that issue, they bury it at the third point. It's less than 2 pages long. All they say, they don't point out any facts that are in dispute. All they say is you can't consider our affidavit because it contained legal conclusions. Saying we didn't get the notice is not a legal conclusion. That's a factual assertion. So what is the issue of fact? It's easy to say there's issues of fact. What's the issue of fact? We say there was no notice given. They don't say anything to the contrary. I think my arguments on the content of the letter are well taken, but I don't see how we get there on the record before this court at all. There's just nothing before the court establishing that they authenticated that letter. I think that on the content of the letter, if you do want to get there, that the issue of this amount, it's not just the amount issue. You should be able to pick up the letter and know what you're supposed to do. That's the essence of anything that's consumer protection oriented. You shouldn't have to make phone calls and hope you get someone on the phone. It's the bank's notice. It's the bank's contractual obligation. They drafted the contract. They bolded it. So we shouldn't be doing them favors on their own contract. There's no reason we shouldn't just be able to pick this up and say, oh, this is the amount I'm supposed to pay. And also specifying the default. The note and mortgage have tons of payment obligations, property taxes, insurance, monthly mortgage payments. If it's monthly mortgage payments, which months? This letter doesn't say. All it says is your loan is in default because you have not made the required payments when they came due. Well, what payments? I just gave you a few examples of the types of payment obligations that exist. And this is the default that Your Honor ruled upon in the Judy case, finding that letter did not comply with paragraph 22. That's just one of the defects here.
Your time has expired.
Thank you all very much. Your Honors should affirm the order on review. Thank you.
Your Honor, how much time do I have?
3 minutes and 45 seconds.
Thank you, Your Honor. Just to briefly respond to some of the arguments that opposing counsel made, we did argue waiver. The memo in opposition to summary judgment, I can give you the page cite, it's page 200 in the record. It was a very extensive memo citing lots of legal arguments, explicitly denial of performance or occurrence to be made specifically and with particularity, so that our argument was preserved. As to the preserving the record, the order of dismissal, there is error on its face. There does not need to be a transcript when it is apparent from the face of the judgment what the error is. We are alleging that the court improperly decided that the breach letter did not comply with paragraph 22 of the mortgage. That is apparent from the face of the order itself. It is obvious what was argued in front of the court. And lastly, the idea that the answer to the, that the plaintiff's filing of the amended complaint, then therefore, an answer to an amended complaint stands over, an answer to original complaint stands over as an answer to amended complaint, providing the amended complaint is so substantially similar to the original complaint. The amended complaints changed nothing regarding the allegations against the defendant. All the amended complaint did was include allegations against the homeowners association. It did not affect the borrower whatsoever. The whole gist of the case was that the court said that this breach letter was insufficient, and there was a lot of talk about substantial compliance. There hasn't been any reported case law of substantial compliance, even though it is stated throughout many decisions that substantial compliance is the law when it comes to condition precedent. It is time to put substantial compliance as a condition precedent in the mortgage foreclosure action. We've danced around it in lots of different decisions, but I think it's clear from the recent cases that that is the analysis that the courts are using, and I think is the one that should be used from now on. Thank you, Your Honors.
Thank you. Thank you both. That will conclude our 9:30 session.